What kind of arguments happen in an appellate court? Imagine a courtroom where no new evidence is presented, and the focus is entirely on the law. That's what happens in an appellate court. Instead of witnesses or new facts, lawyers argue about legal issues. They review what the trial court decided and see if any mistakes were made. Most arguments in these courts are about how the law was understood and used. Lawyers ask if the trial court correctly interpreted statutes, legal rules, or constitutional rights. They might say the court misunderstood a law or applied it wrongly, or they might defend the trial court's decision if they believe it was correct. Appellate courts also look at how the law should be reviewed. Sometimes they do a de novo review, which means they consider the legal question from scratch without respecting the trial court's opinion. Other times they do an abuse of discretion review, where they check if the trial court's decision was unreasonable. And for factual findings, they often use a clearly erroneous standard, meaning they only reverse if the facts were clearly wrong. Arguments will focus on which standard applies and whether the trial court's decision should stay or be changed. Another common argument involves specific decisions made during the trial. Lawyers challenge whether evidence was properly admitted or excluded. They may argue that jury instructions were confusing or incorrect. If the trial court made procedural rulings, lawyers might claim those decisions unfairly affected the case. Attorneys also discuss broader issues like how a ruling might influence future cases or legal principles. They might argue that a decision should follow existing laws or that it needs to be changed to reflect new policies or fairness. During oral arguments, lawyers respond to questions from judges. The judges might ask hypothetical questions to see how a ruling could play out. Lawyers need to be clear and quick in their answers, showing they understand the case record and the legal rules. Before the hearing, both sides submit written briefs. These are detailed documents explaining their legal arguments, citing laws, previous court decisions, and the trial record. Judges relying heavily on these briefs to understand the case. So, arguments in an appellate court mainly focus on whether the law was applied correctly, if the trial court made legal mistakes, and whether the decision should be upheld or changed. It's all about legal reasoning, not new facts, and lawyers use both written briefs and oral responses to persuade the judges.